The decision to divorce is often emotionally charged and complex. According to recent CDC data, Maryland's divorce rate stands at approximately 2.6 divorces per 1,000 people. However, circumstances change, and you may find yourself reconsidering this significant life decision. Whether due to reconciliation, financial concerns, or family matters, many couples experience second thoughts after initiating divorce proceedings. The critical question becomes, can you cancel a divorce in Maryland once it's been filed? To understand your options, it's important to first grasp Maryland's divorce laws. The state recognizes two types of divorce. Limited divorce, which is essentially a legal separation where spouses remain married but live apart. And absolute divorce, which permanently terminates the marriage. Absolute divorce can be granted on either no-fault grounds, such as mutual separation for at least 6 months, or fault-based grounds like adultery, cruelty, or abandonment. If your divorce is fault-based, reversing the process may be more complicated, though not impossible. The stage at which you attempt to stop divorce proceedings largely determines how straightforward or complex the process will be. In the early stages, if you've filed for divorce but the court hasn't yet processed your petition, you can typically withdraw the case with relative ease. Once the court has begun processing your filing, you can still file a request for voluntary dismissal. This requires submitting a form to the court asking to dismiss the case. If both spouses agree, the court will generally grant the dismissal without a hearing. However, if one party objects, a hearing may be required to determine whether dismissal serves the best interests of all parties. As your divorce nears finalization, or after a settlement has been signed, stopping the process becomes significantly more challenging. At this point, swift action and professional legal guidance becomes essential to explore your remaining options. For a successful divorce reversal in Maryland, several steps are typically necessary. First, discuss your intention with your spouse, as mutual consent simplifies the dismissal process considerably. The spouse who initiated the divorce must file a formal motion to dismiss the petition with the court. If the respondent hasn't yet filed a response, dismissal is usually automatic. However, if a response has been filed, both parties may need to sign an agreement confirming their decision to withdraw the case. In some situations, particularly in contested divorces or when significant legal proceedings have occurred, the judge might require a hearing to verify that both spouses voluntarily agree to the dismissal. Once the judge approves the request, the court will provide a ruling that formally terminates the case, meaning you and your partner remain legally married and any pending proceedings related to property division or child custody will cease. If your divorce has already been finalized, the situation becomes far more complex. Unlike withdrawing a petition before finalization, reversing a completed divorce is extremely difficult as it has legally ended your marriage. Before proceeding with canceling a divorce, carefully consider both emotional and practical factors. Ask yourself whether you and your spouse genuinely want to reconcile or if external pressures are influencing your decision. If your marriage has serious underlying issues, counseling might be advisable before making your final choice. Additionally, consider financial implications, particularly if you've already divided assets or made financial commitments based on the expected divorce. In situations where only one spouse wishes to cancel the divorce, open communication or mediation may help both parties reconsider. If you filed the divorce petition, you can file a motion to dismiss, but if your spouse is determined to proceed, the court will likely allow the divorce to continue. In conclusion, while Maryland law does allow for canceling a divorce, the window to act is limited and becomes increasingly narrow as proceedings advance. Whatever your circumstances, consulting with an experienced family law attorney provides the best opportunity to understand your options and navigate this complex process effectively. Remember, the decision to reconcile should be mutual and driven by a genuine commitment to address the issues that led to filing for divorce in the first place.